My name is, I live in White City. I'm not a resident here, but I am a student at Southern Oregon University. I'm a senior. I'm summa cum laude so far. I have 4 classes left. So I do have an interest in what goes on in Ashland. I served 18 years in the United States Marine Corps, 5 years working for county government following that, and several years in political appointments, including planning commission and an airport commission. And all of those jobs, I took an oath to the Constitution and whatever local area I was in. That oath has no expiration date. I'm here tonight to speak to you about the firearms ordinance that the media says that you may be considering shortly. Law-abiding firearms carriers simply aren't a legitimate safety concern for the public in the city of Ashland. I'm pretty sure that the chief, if you asked him, could not show you statistics where law-abiding firearms carriers openly carrying weapons were an issue. If there's no issue, there shouldn't be a law. State law covers it anyway. Nothing you do will affect what criminals do. Now, this is not any animosity towards you, but I'm a criminal justice minor at SOU, so I wanted to point out the laws. The city does not have the authority to ban firearms. It only has the authority to ban the carry of loaded firearms by those people who do not have concealed handgun licenses. Anyone with a concealed handgun license can openly carry anywhere in the city, with the few exceptions that are pointed out in state law. I'm openly carrying right now. That's under ORS 166.170. It says that nobody can pass anything banning firearms or regulating firearms unless it expressly authorizes you to do so. Ordinances that are contrary to that Oregon statute are void. Not just the part, but the law says the entire ordinance is void. Now, what can you do? The Oregon State Legislature has expressly authorized you in their 166.173 to regulate the carry of loaded firearms by persons who do not have CHLs. There's a few other exemptions, but basically for the public, if you have a CHL, you're exempt. You cannot regulate the carry of unloaded firearms, nor can you regulate under Oregon state law the carry of magazines that have ammunition in them, like the cities of Portland and a few others and the county of Multnomah do. They have a much larger budget than you do. They have attorneys on full-time staff. I'm not sure if your attorney is, and they can afford to pay lawsuits if they lose them. They don't lose those lawsuits because whenever they charge someone with this type of a crime up there of their ordinance, they drop the charges. Kevin Starrett from Oregon Firearms Federation can verify that. Every time somebody gets charged, they drop the charges before it ever goes to trial. So there's another reason not to pass an ordinance that has things that you don't have authority to do, because then you're going to be tied up with trying to figure out what you can and can't do. You do have the authority to ban the loaded carry by non-CHL holders if you want to go there. Green light's still on. Good. Further, the aspect of stopping all gun carriers to inspect their weapons. This is a big one to me. 18 years in the Marine Corps, I did run pistol ranges. When you're touching a weapon and handling it, that's when it fires. So if you're a police officer, and I'm sure the chief is not going to want his officer to have to do this, if your officer comes up and he wants to inspect the weapon, that's when a firearm accident will happen, taking the weapon out and looking at it. If the person gives them a CHL, they're not going to look. If they don't have a CHL, they're going to pull that weapon out. Now, they would be in violation of law if they didn't. The problem is that under the Constitution of the United States of America, you must have reasonable articulable suspicion that a crime has been committed in order to detain an individual. And the ordinance text that I've seen, I don't know if that's what you're looking at, specifically states the officer can do that just by mere presence of the firearm. The Fourth Amendment under Supreme Court precedent in Terry v. Ohio, the officer has to have a reasonable suspicion that a crime is being committed. And Florida v. JL and other cases, the Supreme Court has said there is no firearms exception to the Fourth Amendment. Therefore, if an officer sees a gun being carried by a citizen, and that's the only thing he sees, he does not have reasonable articulable suspicion to detain that individual. Stopping someone to inspect their weapon or force them to produce a CHL is a detainment per Supreme Court precedent. So the ordinances I've seen it written, and the ordinances as they do in Portland And,
You got about
Multnomah.
20 seconds.
okay, Portland and Multnomah, they're unconstitutional, and they avoid the constitutional issues by dropping the charges. The other thing is, I'm an open carrier. I carry in this area, not always down here in Ashland. I can guarantee you that the unintended consequence, just from the people I've talked to, of passing this ordinance will be to make Ashland the destination of choice of every open carry activist there is in Southern California.
Thank you. You need to wrap up now.
Thank you. That's how I wanted to close. So,
Thank you.
thank you, sir.